Good afternoon, everybody. I hope you guys on Zoom can hear me well as well. Yeah? Okay. So it is my great pleasure to introduce our speaker today. That's Julen Etxabe. Assistant professor in Allard Law and Canada Research Chair in Jurisprudence and Human Rights. And for those of you who didn't have a chance to, get to know Julen, just a few bio information. Julen's current research combines legal and literary theory to identify a new model of dialogical judgment emerging in the area of human rights, which is transforming inherent notions of reasoning, rights, authority, and law in the post-national and diverse societies of the 21st century. Prior to joining UBC, Julen was a core fellow at the Helsinki Colloquium of Advanced Studies and postdoctoral researcher at the Center of Excellence in Foundations of European Law at the University of Helsinki in Finland. In addition, he has been a visiting researcher at Reed College in Portland, Oregon, and Australian National University College of Law, the School of Law and Justice in Southern Cross University in Australia, and in St. Louis in Brussels. St. Louis, sorry. He has taught both graduate seminars and undergraduate courses at the University of Michigan, at the University of Helsinki, and supervises doctoral students in several areas of law and interdisciplinary studies. So without further ado, I'll hand it over to you, Julen, and thank you all for coming to Faculty Colloquium Series today.
Thank you very much, Liliana, for such a kind introduction, and for all of you who are here and are seeing us through Zoom, because I know there's a lot of things going on simultaneously. If I weren't speaking, I might have gone to a different event. So thanks for coming and joining us here. So what I want to do today is explain this, what I am calling this dialogical model of judgment. And so I'm just going to tell you a little bit the big picture of what I think this model is. I wish that I had a developed paper when Liliana mentioned that she asked for volunteers for presenting. I thought by this time, for sure, the paper will be written. I also wish I also had a nice PowerPoint presentation for you, which I don't, so you'll have to listen to me in the old ways. But I'll tell you a little bit about how it is that I began to be interested and how it is that I started to think of what I'm going to present as a model. And what I mean by that. So I started being interested in the phenomenon of, as my students know, on cross-judicial referencing and cross-referencing across different jurisdictions, which has sometimes been labeled judicial dialogues. At the same time, I was reading a lot of Bakhtin, so I thought, oh, there's actually something quite interesting there, and I was interested in those borrowings, pollinizations, but how it is that meaning changes from context to context when it's borrowed from one place and put and localized, vernacularized in a different context. But the more I read the judgment of the European Court of Human Rights, which is the court about which I'm going to be talking today, the more I realized that this was not just simply a practice about citation foreign jurisdictions, but it was actually something that was pervading the entire process of judgment of the case, to the extent that I started to think about it as a dialogical model, a model of judgment that is dialogical through and through. So what I'm hoping to do today is to present to you this big picture, because I haven't had the chance yet to present that big picture, so it's mostly for the sake of my benefit that I'm doing this presentation in this hopefully not too intimidated an audience, but you'll have to forgive me because I'm going to be quite schematic and quite fast. And some of the arguments that I will be making will require much more detailed textual demonstration. But what I want to do instead is to present to you the picture and contrast it with the two main other models which are out there to explain, to frame the work of adjudication. And to show you how this model is somewhat different and it cannot be subsumed under any of the current models. I would like to eventually come to writing this piece, so that's my next step. So I would really welcome comments, questions, feedback, and so forth. So what it is that I mean by a model first, because the work that I'm going to present to you today is uncharacteristically, for me, somewhat conceptual. And speaking about models might give you, you might raise your eyebrows, what is he talking about? I do not mean a Platonic ideal or a template or a prescriptive theory as to how judges are supposed to adjudicate conflicts over human rights. There are excellent theories about that, namely, for instance, George Letsas, or Stephen Greer, or Conor Gertie. They have that kind of a prescriptive theory of how judges are supposed to adjudicate conflicts of human rights. Rather, what I mean by a model is this overall picture of the task of human rights adjudication and how to make sense of it. I will focus on the European Court of Human Rights. I will refer to it as the court for short, because it has developed, in my view, a quite distinct dialogical practice, but I don't believe it is alone in developing a dialogical model. Notably, the SEC in Canada and the Constitutional Court of South Africa are developing their own dialogical models, and hopefully something of which I will be saying today is going to be relevant also in those comparative contexts. It is important to say that these features, these characteristics that I will tease out, do not always follow a deliberate or intentional pattern. Rather, they emerge from the practice as a form of a collective intelligence. And therefore, they go beyond the work of any specific judge or any court decision. By painting human rights adjudication with a dialogical palette, I seek both a redescription of the court's practice and also to provide a general horizon that can serve to guide it. Accordingly, I do not claim that the court always conforms to such a model, nor do I in fact argue that the dialogical model displaces the two other competing models entirely. After all, adjudicating human rights claims is ostensibly still a matter of adjudicating conflicts over rights, however understood, and the process of reasoning and justification often follows the steps analyzed by proportionality analysis, which is the second model. So better to think of it as a third variant, because I do think, though, that the dialogical model has some distinctive features which are not contemplated by the other two and cannot be subsumed under them. So before I begin, a few preliminary clarification about my use of the term dialogue and dialogical. It's an adaptation from Mikhail Bakhtin, as I already mentioned. This is, of course, not the place to go into details about the theoretical underpinnings of Bakhtin. I do have a law review article coming in Osgood Hall Law Journal now, where I try to develop a non-positivistic, a non-propositional theory of both language and law. But for the purposes of this presentation, in particular, what I borrow is this notion of dialogue, which is not averse to conflict or blind, in fact, to power dynamics, but rather presupposes a tension-filled universe in which we are always speaking with the language of others and tossing it back at our interlocutors. My second clarification is that while I hold on to the term dialogical, I think there is value in it, I want to distinguish it specifically from what the so-called dialogue theory in Canadian constitutional law, which views courts and parliaments as co-equal branches of government. Such a theory is largely institutional and does not account for the deep pluralism of the dialogical model that I'm talking about today. So before I go on to explain its key features, it is necessary to say a few more words about the other two models with which I am contrasting it. The first is the rights-centered model. The most well-known jurisprudential account is Ronald Dworkin's Rights as Trumps, where rights are understood as moral duties. The state owes rights bearers as free and equal citizens. The guiding question for the judge is, does the petitioner have a right to? And parties are entitled to the judge's best judgment as to what their rights actually are. This model explicitly rejects the idea of balancing individual rights with the demands of society. For rights, properly speaking, cannot be outweighed by arguments of public utility or general welfare. This right-centered model is often associated with the US Supreme Court as having a categorical or rule-like approach to rights. This, for example, has been recently criticized by Jamal Green in a very interesting articles and book. George Letsas, who is a former pupil or disciple of Dworkin, also applied it to the work of the European Court of Human Rights, or the court. In his view, the European Convention, that is mainly the foundational text, where all the Canadian Charter, enshrines, in his view, rights as liberal egalitarian principles that should be extended equally to all 800 million Europeans under the convention regime. Therefore, adjudicating the convention is ultimately not about a matter of balancing or maximizing interests, but, and I'm quoting, a matter of applying consistently the moral principles that underlie rights. There are many objections to this model. I'm not going to go through them, but suffices to say that I do think that it does not describe the practice of the court. Because in their judgments, there is never, or there is very rarely, univocal moral principles across the board. Judgments are highly contextual and sometimes country-specific. Moreover, the leading question is not whether the individual has a right, but whether the state has in fact violated its obligations, which I will argue is a very different kind of judgment. So that's the first model, the rights model. The second model is proportionality analysis, which has origins in Prussian administrative law, but it has gained traction after the Second World War as the global language to adjudicate rights. It's employed not only in Europe, in Canada, in South Africa, but in Israel, in Latin American countries such as Colombia, Brazil, Mexico, in India, South Korea, Taiwan, Hong Kong, Malaysia, and so on and so on. So rather than categorical rights, proportionality analysis uses the language of weighing and balancing as a form of empirically assessing individual and collective interests. Jurisprudentially, the most elaborated theory is that of Robert Alexy and all his followers. According to Alexy, rights are better characterized as norms that set up principles. By principles, he means optimization requirements. That is, things that require to be satisfied in varying degrees, more or less, not like rules which are all or nothing. So principles are optimization requirements. So having a right in Alexy's sense does not entail the individual to prevail over any countervailing consideration of policy, but merely triggers an assessment of whether the infringement is justified. Certain steps to determine, therefore, if the interference is justified, which are very well known in the Canadian context, a 3- or 4-prong analysis, which is quite well known since the Oakes test. Whether the interference pursues a legitimate aim that is foreseen in the law, whether the means are suitable, rationally connected, whether they are necessary to accomplish the aim, and in the Canadian context, where they are the least respective means, and or, because it depends on the theories, whether they are strictly speaking proportional, namely whether the benefits outweighs the costs. Despite broad scholarly consensus, I see several shortcomings of this model as applied to the European Court. The first shortcoming is that it's quite inattentive to language. The test is presented as a matrix to structure the reasoning process, but it is impervious to their actual articulation by the parties. Secondly, it is also inattentive to the positionality of the judge. The metaphor of balancing imagines the judge as holding up the balance, but this leaves the judge outside the purview. And thirdly, perhaps substantially more importantly for me, the proportionality test does not leave room for discussing the kind of society at stake in every human rights case. Both the society envisioned by the judgment and the one that will obtain if the state action in question is left to stand. Certainly, this judgment is much more complex than putting the respective interest on the scale and declaring which one weighs more. So partly to remedy these shortcomings and partly as an attempt to describe the practice more adequately, I want to propose the contours of what I'm calling dialogical model. I will identify 6 different stages or dimensions of the dialogical, but in the interest of time, I will run some of them rather quickly, but as I say, I prefer to give you the full picture than spend more time in all of them. But you should know that each of these stages or dimensions is quite complex on its own and dialogicized through and through. In substance, what I will argue is that first, the court constructs its judgment on the shoulders of others, that is not autonomously. Second, it does so as an active participant, not simply as an external referee, but without supreme authority, not even when interpreting the convention. And 3, the court sees itself as engaged in deep and politically sensitive conversations about the character and fundamental values of democratic societies. So the court is a political actor. First, the first stage, the first dimension that I want to talk about is the framing of the case, the framing of the claim, sorry. So a victim of human rights violation must present their claim in the language of the convention and identify the state action being challenged. Evidently, not all claims are legally cognizable or fall under the jurisdiction of the court. In fact, only a fraction of all applications are declared admissible and only after having exhausted all domestic remedies. What this means is that there is usually a long domestic proceedings prior to the application, which ends up finding its way into the final text of the opinion. You always find that proceedings inside of the text. So the key aspect to retain from a dialogical perspective, though, is that by the time the application reaches the court, the claim is already languaged. A scaffold of arguments and counter-arguments that filter the way accesses the case. This doesn't mean, though, that there is no leeway for creative reframing. A very interesting example that I will mention is the López Ostra v. Spain, 1994 important case where the applicant had suffered environmental harms due to a nearby waste treatment facility. There is no obvious article in the convention that addresses those harms, nor was there the waste treatment facility publicly owned. But the applicant argued that the failure of the state to take any action affected the right to private and family life and the protection of their home. It is Article 8. In characteristic fashion, I will claim, the court did not shut down the argument simply because it was unconventional. And eventually, in fact, accepted it because they argued that serious pollution can impact how an individual's well-being, and prevent her from enjoying her private and family life, which is basically true, which it was not as certain in 1994 when the court said that. So the takeaway for our purpose is not this specific judgment, but the fact that the court's approach is dialogically responsive to the way it has been framed by the parties. The second dimension is what I call understanding the case as a whole. right? Applications usually list a discrete list of potential violations, and the court tends to analyze them one by one, but all the time arguing that the review requires taking the case as a whole. In fact, the case rarely hinges on a strict textual readings of any specific article. This is because, as the court says, the convention is a living instrument which must be interpreted in light of the present-day conditions and of the ideas prevailing in democratic states today, which is a mantra they repeat. Furthermore, they prefer interpretations that render the protections of the conventions effective and practical, as opposed to theoretical and illusory. Seeing the case through the prism of the convention, that is, and putting it under the light of its overall purpose, can have the effect of shifting the way the case is being perceived at the domestic and international levels. Bakhtin calls this a surplus of seeing, where our respective positions enable us to see more than our interlocutors, and vice versa. So here I have examples from a line of cases about police torture in Spain, where domestic authorities had examined the cases under the presumption of innocence principle and declared the policeman accused of torture non-criminally responsible for insufficient evidence, like a very clear case of presumption of innocence. Under the different light of the convention, however, the court declared that the authorities had failed in their obligation to pursue a full and adequate investigation. In particular, state authorities had still to provide a convincing explanation of how the injuries sustained by the applicants had in fact occurred. And so it really shifted the way that the case was being analyzed. The third stage I want to call normative embeddedness. As stated in a 2008 judgment, the court has, I'm citing from the court has never considered the provisions of the convention as the sole framework of reference for the interpretation of the rights and freedom enshrined therein. So it is not like a constitution, against the views, for instance, of Stephen Greer. The case is to be situated, therefore, in yet a much broader constellation or environment, normative environment that provides a background to interpret it. The framework of reference provides the spatio-temporal coordinates that envelop the case, which is exactly what Mariana Valverde, borrowing from Bakhtin, calls a chronotope. So bringing this normative background, this dense web of norms into the text of the decisions, a judicial opinion usually contains a rich polyphony of voices, practices, norms, domestic and international. A particularly rich dimension is the inclusion of judgments of foreign courts, a phenomenon that has been studied under the heading of judicial dialogues. From a Bakhtinian perspective, the curious effect of these mutual borrowings is that the borrowed language can talk back and affect the interpretation of the issue. A very interesting case, famous case, is the Hearst case on prisoner voting rights, where citations of the Canadian Supreme Court and the Constitutional Court of South Africa were employed by the court against the British authorities who had originally cited them. A fourth stage or dimension, assessing its own jurisprudence. It's a question about positionality and trajectory. The court operates under no formal doctrine of precedent, but will not depart from previously laid down cases without good reason. That's a principle that they establish. Whereas this provides some measure of stability, in the same breath, that is a continuation of that citation I mentioned, the court assures us that a failure to maintain a dynamic and evolutive approach will risk rendering precedent a bar to reform or improvement. Hence, the court places its own jurisprudence in a world in constant movement. Assessing precedent is therefore a self-reflexive exercise of positioning its own past self, and projecting it into the present and the future. One remarkable dialogical feature is that instead of acting as a jealous guardian of its own jurisprudence, as purportedly the high interpreter of the convention, it does not always subject to domestic interpretations of the same in a dialogical fashion. The fifth dimension or stage is what I call relational authority. In the international context in which it operates, the authority of the court is not only subsidiary, but it is mediated and relational. For example, the famous doctrine of margin of appreciation stems from the recognition that national authorities, by reason of their direct and continuous contact with the vital forces of the country, that's a citation from the famous case of Handyside, are in principle better placed than an international court to evaluate local needs and conditions, like very well-known language. This affects obviously the standards of review as well, because the court says it is in no way the court's task to take the place of the competent national courts. But at the same time, the margin, they say, goes hand in hand with European supervision over the measure in question and over the reasons that used to support it. So it's a two-way stream. Such relational form of authority gives rise to a curious feature that I have elsewhere analyzed as double voice discourse. Namely, it's a narrative voice that departs from the more conventional, monological way of expressing judicial authority. By double voice discourse, Bakhtin meant the kind of utterances which are internally inhabited by at least two different standpoints, that are spoken by at least two voices at once. So typical double voice language of the court, and here we could go list many examples, includes very distant, very attenuated language of the kind, the competent domestic authorities were entitled to think that, not that they were right to think that, but they were entitled to, or the law might be regarded as pursuing the ends identified by the governments. Alternatively, when the court wants to contradict or to challenge the government's claims, it can often say, but obliquely, the court finds it difficult to agree, or the court is not able to discern a legitimate aim, never affirmatively or assertively. This is from a Russian case called Savanchiyeva. So double-voicedness allows the court generally to abstain from clashing head-on over controversial issues, but it can incorporate controversial arguments, and I think this is key, in a refracted way, that is, as arguments of others that are included in the judgment. Further, double-voicedness enables the court to engage in a parallel conversations with more than one interlocutor and send different messages to each. In the very famous case of Escopola v. Italy, which is a continuation of the Hearst case of prisoner voting rights, the court is ostensibly speaking to the Italian authorities, but underneath their expression, there is an undercurrent conversation they're having with the British authorities, who had petitioned the court to revisit their earlier precedent in Hearst. So, and I argue that they say different things to both of these interlocutors. The final dimension, and the one that I find is more crucial, is what I am, and the most defining in a sense, is what I call a judgment of democracy. Because in every decision, the court makes a judgment about the type of democratic society that it envisions, both in the values it espouses, and in deciding whether to uphold the state action in question or whether to declare it contrary to the convention. I argue that in this judgment, there is an ineradicable tension between two contrasting concepts of democracy. The first one is democracy as a regime or an institution. The second one is democracy as an ideal or an aspiration. As a regime, democracy refers to a system of government chosen in free and general elections that respects the separation of powers, the rule of law, and guards the exercise of public authority. But democracy can also refer to the aspirations behind such forms of government, including pluralism, spirit of tolerance, they speak about that, equality, non-discrimination, respect for minorities, to name a few. The list is non-exhaustive and refers to broad societal aspirations towards more equitable, inclusive, and just societies. As an ideal, then, democracy is unclosable, or to use a Bakhtinian term, unfinalizable. It is also essentially contested and doesn't evolve in a single direction of inevitable progress. My point is that the tension between these two concepts is structural and runs through the entire system of the Convention. On the one hand, doctrines such as the margin of appreciation and principles of subsidiarity are mindful of the institutional conception of democracy, leading to forms of judicial restraint. On the other hand, the living instrument method of interpretation and the principle of effective protection of human rights are aligned with the ideal or the aspirational concept of democracy. The clearest doctrinal manifestation of such tension is in the restrictions of Article 8 through 11, where interferences in the Convention rights can be justified if they are deemed to be necessary in a democratic society. Obviously, similar language can be found in Section 1 of the Canadian Charter, which talks about a free and democratic society, and also in Section 36 of the Constitution of South Africa, which talks about an open and democratic society based on dignity, freedom, and equality. There, the substantive values are quite evident. Scholars argue, though, that the European Court uses these concepts quite loosely and mostly in a rhetorical manner. So it's not part of the test of proportionality as they understand it. However, and this is important, I think, the limitation clauses do not speak of necessity in the abstract, but of a kind of necessity specifically democratic. However fuzzy, however vague, democracy then must be a yardstick against which to assess the nature of the restrictions. As the court emphasized in the landmark case of the United Communist Party of Turkey versus Turkey in 1998 decision, and I'm citing the court, the only type of necessity capable of justifying an interference with any of these rights is therefore one which may claim to spring from democratic society. As a result, the moniker necessary in a democratic society cannot be taken as an empty formality. However vague, however contested, democracy must be a factor in assessing the justifiability of the interference. So how is this judgment done? And it's part of my argument about the dialogical nature of the judgments of the court, that this is not an independent moral judgment, but it depends upon all those previous stages, all the previous dimensions that I've been talking about, the framing of the claim, the understanding the case as a whole, the thick normative background, which provides the direction and trajectory of the jurisprudence, and the relational authority of the court, to name a few, and what I've said, this tension between the institutional and the aspirational concepts of democracy. So with the determination of whether, or not a given restriction is democratic requires highly contextual and dialogically constructed judgments, which are not just categorical determinations of individual rights, on the one hand, nor they are balancing on contrasting interests only. Rather, these are a kind of political judgments, which Robert Boehner explains always are, implicitly at least, I'm citing from Robert Boehner's book, about the form of collective life that is desirable for us to pursue within a given context of possibilities. Not just what should we do, but how are we to be together, and what it is to be the institutional setting for that being together. As judgments about our collective lives, these are not freestanding decisions. They are more like wagers that depend on other actors to come to fruition. Or, as Bakhtin might put it, it relies on a structure of answerability, by which an utterance is thrown to an audience who actualizes its meaning in their response or lack thereof. So I'm just going to conclude saying that in a dialogical model, the court is engaged not just in the judicial determination of rights, not just in balancing individual and collective interests, but in the construction of a vision of a democratic society. This is a role beyond what John Hart allies conceive as the democracy-enhancing role of the judiciary in order to unblock stoppages in the democratic process. Eli conceived this task mainly in procedural terms, but the dialogical model is also democracy constituting, as the court's judgment become contested sites for discussing the rights, obligations, and aspirations of democratic societies. In this setting, the court is an actor with unavoidable responsibilities, but without supreme authority. Thank you.
Thank you very much, Julen, for this, inspiring, really rich talk. So I would like to suggest that you maybe take a look and of a queue of questions coming from the room, and I'll look into questions coming already on Zoom. And, we proceed first with the room, and then I have some people on Zoom as well. Okay?
I see Mary.
Thank you, and this is so fascinating. It's just a bit of an eye-opener in a way I hadn't anticipated. And so I have kind of a question. And then I have thinking about what you've been talking about in relation to the Canadian Supreme Court. So that's maybe an opportunity to have a dialogue about that. But the first thing that struck me about the way that you were talking about this dialogic model was it provides a better way, in some ways, to teach students about legal principles and how legal principles are contextual and open-ended and inherently multi-voiced. They aren't like rules. So they demand that kind of creative exercise, a legitimate creative exercise on the part of a reviewing court. And it explains principles in a way that's a little different than Ronald Dworkin, and maybe even a better way. In order to, explain, describe, justify, and critique the interpretation of principles. And so Bakhtin may be better than Dworkin in explaining legal principles is one hypothesis that I'm starting to think about. And it made me think about, in Canada, a particular practice we have, which is a genre of legal case, the reference case, which themselves are political judgments, right? So it's advice to the other branches and to the political community about what the court thinks is the best answer to a legal question, but they are not, strictly speaking, binding judgments. And so again, they have that kind of political openness to them, which resonates with this dialogic model. They aren't positivistic, as you have described it. They're kind of dynamic and contextual. They're openly normative. And they often, like the secession reference, right? They span an analysis of centuries sometimes about what we aspire to in a democratic society, but also the legal frameworks, the institutions. And so it strikes, and also they have a zillion interveners usually, so there's that kind of multi-voicedness. And so we don't spend a lot of time talking about reference cases as a genre in law school, I think. But again, it strikes me that that might be an interesting way to talk about them as something different than like ordinary cases, actually. And they're often so heavily dependent on principles. And then the third thing I thought is, and again, it's not clear always why the court does this in Canada, but I was thinking about your use of this idea about double voicedness, or I suppose like plural voicedness, if we take it deep way, versus monological voice. And does that possibly, this way of talking about voice in legal judgments, provide a possible evaluative standard for when certainly the Canadian Supreme Court decides to issue judgments in the name of the court, instead of so-and-so wrote this? And it's usually this unified judgment, speaking for the institution. And it strikes me that's a very different voice than when you get in a usual case where you might have a majority in concurrences and a dissent, and you can identify who says what because they tell you what they think. And so again, that's kind of shutting down. I don't know if I'm right. I have to think this. Is that a way of shutting down? Is it a bad way of shutting down this double voicedness? Is it a bad way of avoiding answerability because it's monologic? Like, is that a way of thinking about the actual structure of that judgment and the way it's expressed in the voice of the court? I guess there must be European Court of Human Rights analogs, like they must speak for the court as well. And that.
I'm speaking for the court as a shorthand. Those are great questions. Regarding the first one, I agree. that Bakhtin is much better to understand legal principles than Dworkin is. I had to tell my master's student that, but it's a step thing because you do have to do a lot of translation in order to make it meaningful. The distinction between Alexei and Dworkin is quite interesting, but I do think that it could be still enriched. The second question about the genre of references, I was thinking that in the European context, we have references, but they are to the Court of Luxembourg, not to the Court of Strasbourg, which is the one that I'm talking about, the European Court. So the ECJ receives questions from domestic courts who are uncertain about the meaning of European law. But there, the genre is quite dogmatic, because the court itself thinks it's the interpreter of the treaties, right? The interpreter, the authoritative interpreter of European law. And the courts expect that answer. They expect a univocal answer because they are in doubt as to what's the meaning of European law. So I guess the genre could go both ways. I find that the style of the European Court of Human Rights is much more conducive to the dialogical model than the model of the Luxembourg Court, which does not allow even dissents. Anyway, there might be other features of the judgments, which, for instance, the advocate generals have a role to play as well. But I think it's important that we make that more expansive. Concerning double voicedness, the context of these, why I'm bringing this up is because there is this very famous article by Robert Ferguson who talks about the judicial voice. And recently also Paul Kahn talks about the judicial voice, and he talks about the charismatic voice of the judge, Justice Marshall. That sense of voice coming from heaven to elucidate legal principles and so forth. And that might be true as a descriptive of Marshall, but what I'm claiming is that does not represent the genre as a whole. And there might be other ways of talking and being authoritative without being authoritarian. And I do think that the idea of double-voicedness is expansive in that sense. It allows us to speak more ambiguously when we're uncertain, and nevertheless say the things we want to say. It's not just simply, and that's why I was putting examples, not only of allowing the state to get away with murder, but some way to speak to the different constituents and saying different things to each. Is, I think, a different way of thinking of how it is that authority is constructed. Because both Ferguson and Kahn think that the construction of judicial authority, the judicial opinion as a form, has to have this authoritative voice. And I'm just wanted to deny that, both empirically, but also as an ideal.
We have two questions also from Zoom. Leora and James, and maybe we can take Leora before you go to another question.
Thank you.
Oh,
Hi, thanks, Julen. That's very, very interesting paper. And I'm a friend of mine, a Greek friend of mine, once said, "You've put me into thoughts." So that's what you've done to me. A couple of things I wanted to say about this. I'm obviously very familiar with the European Court of Human Rights jurisprudence, and so I just wanted to throw out some thoughts. Your arguments center on a set of rights and a set of cases which are about plurality. They're very commonly about limitations because they're centered on Articles 8 to 11, which includes in every article a treaty-based invitation to answer the question, what is necessary in a democratic society? And they're often cases that refer to plural conflicts like religion and other questions. So one of the questions I'd have when thinking critically about this paper would be, is this something we can say about the European Court of Human Rights jurisprudence as a whole? Does it refer also to the positive obligations jurisprudence that's coming out of Articles 2, 3, and 4? Does it account for the procedural rights jurisprudence in Articles 5, 6? So yeah, I mean, that's just a question I had about. The other question I would have is, to what extent is this an account of a regional court and not a national court? Yeah. And that's to do with structure, and that's to do with the self-conscious and self-awareness of the European Court of Human Rights as a trans-European court that has jurisdiction over 47 member states. And this is an inevitable part of the plurality and its dialogic role. I mean, that will be a question of, whether that's then extendable to the sort of more value-based arguments that are in the German Constitutional Court and the Spanish Constitutional Court and the South African Constitutional Court. So that would be another question I would have. And finally, I wondered whether you could, in thinking about this further, whether the later cases that are now referring the margin of appreciation discussion back to the democratic authorities. So the court's been doing a lot of subsidiarity work in the last 10 years, trying to push more assessment back down to the authorities. So like in Hearst, they actually try to defer it back. They're very interested in seeing the national authorities coming back under the margin of appreciation with procedural democratic structures of deliberation. And I thought that might be an enhancing point to sort of evaluate and have a look at the animal defenders case. So those are my 3 comments, or 1 comment and 2 challenges. I don't know what they are.
I'm not sure whether I understood the third of the questions from the states coming back from when the court is trying to defer to them on the margin of appreciation. I will try to say, though, a few words and see whether I'm addressing some of the concerns. My claim is that, to your first question, is that this structural tension about democratic society at play runs through the entire convention, and not only is it specific to Articles 8 through 11 to the limitations clause. So, for example, in the Hearst case, it was about electoral matters, and so it was not about the limitations article. But the case, for instance, about the famous case of Golder about a fair trial, eventually is a question about what it means to have legal representation. And what I want to say quickly is that I think a claimant might be more successful insofar as they're able to frame their case, not as a matter of an individual right which has been violated, but a matter of something that affects us all as democratic societies. And to that extent, the court always tries to begin from a framing of the case where the importance of the right, namely for what it means for a society to have freedom of religion or even the procedural rights is at stake. So I'm trying to extend it. I'm not sure whether you might find examples where that is not the case, but I do think that the undercurrent is that actually that debate, whereas sometimes it's not made explicit. The second is definitely a difference that's why I didn't want to push too much the analogy with the Canadian and the South African context, because I do think there are structural differences in how it is that the courts perceive the role, because they speak for different polities. And to that extent, I think you're perfectly right. And I agree with you that the European Court is much more mindful of the international context in which it operates and for the fragility, or I guess the goodwill upon which it depends for the states to implement their measures. But still, we could bring some of those reflections to the domestic level and think how it is that then the Canadian Supreme Court, or let's say the US Supreme Court, can incorporate an understanding of society which is more plural and dialogic than monastic, I guess. But I agree that the question there is one of going to the specific context and seeing this in the institutional context, how far this applies, what are the worries that the judges are having. I'm not advocating this as a template for all cases, but as a way of thinking about what it is that the court is doing. And the question of the margin of appreciation, if I understood the question correctly, is that I see that as a loop of conversations that in which the court is participating, where they utter a sentence or a judgment, and then the domestic authorities interpret it as they wish. Or as they don't wish, and then they come back with a different interpretation. There's very interesting cases about the case of Winter and Hutchinson, where the question there is whether the European Court interpreted the UK law correctly, and the UK judges say, in fact, you didn't. Let's set it back. And so that's one question that I want to write about next, which is what kind of dialogue are we talking about? That's the question that I have. And I'm going to stop because I see more hands.
Yeah, so we have James and Vincent Joel.
So thank you so much, Julen, for an interesting paper. I'm out of my depth, but I have a set of intuitions that I hope are a little bit interesting. I was really fascinated by this transition between the three sort of concepts that you laid out. The first being a Dworkinian idea of rights as trumps, the second being rights considered within a context of proportionality, the third being a dialogical model. And I tried to think for myself, what was the sort of the essence conceptually that tied all of these together? And I had a hypothesis that I'd be interested in your thoughts about, that this is actually a theory of weight that will be assigned to particular values in adjudication. So the Dworkinian idea places great weight on rights in the adjudication. The proportionality stage places less weight on rights as such, and through this diminution of weight, it invites judges to weigh a whole range of factors, but doesn't necessarily announce how that weight will be accorded and what those factors are. And then I thought, if my thinking about the first two is correct, what is the essence of weight in the third, in the dialogical? And I wondered if it involved conferring weight on the framing of stakeholders. And so one would confer weight on the fact that the parties in litigation conceived of the dispute as being one about human right X, or that the state existed in a particular relationship with the court, which was also another stakeholder, that democracy was a political theory that represented something that was an important set of relationships for this particular adjudication to take place in. So if my idea about weight flows through all three, I do get to the problem at the end where I wonder whether it does enough work in solving the core problem as a descriptive theory of adjudication, because it strikes me that the dialogue or the stakeholders can cut both ways. They can promote all sorts of values that we might think are noble and important in adjudication, but they might also undermine those values, and we need a theory to determine which we should place weight on in our decision-making process. And so, for instance, margins of appreciation can be so broad that they're arguably inconsistent with the core idea of human rights, and the exception swallows the rule. Judicial dialogue can be a basis for hegemony, or as Gunther Teubner talks about, the transposition of legal irritants from one legal system into the next. And unfortunately, to sort of come back to the contemporary world, the process of dialogue might not be a vector for promoting democratic values. It might be a vector for promoting authoritarian values. And so I just wonder what you think about this idea of the three being theories of weight, and whether the third necessarily answers the questions we need it to answer.
Thanks, James. I will not necessarily use the language of weight, which is heavily associated with the proportionality analysis model. And Ronald Lexi has what he calls the weight, what is it? The equation. It's like an equation where you can put different values into different factors, and it just gives you an answer as to which one weighs more, which is a horrible way of thinking about what the task is. But let's assume that it's all about the weight. So you're asking me, where is the weight in the dialogical model that I am advocating? I specifically will try to avoid to say that I'm advocating a prescriptive theory about how judges should work. I'm not going to tell them, at least not now, what it is that they should be doing. I'm trying really to grasp at certain key factors that I think are essential. So I guess the answer, though, is that, as a lawyer will say, the answer depends case by case and depending on the context. And so all those factors must be weighed in, to speak of the metaphor of weight now. And perhaps the institutional factor of democracy, the institutional model of democracy must gain preference in one context, in one case. Other times, the more aspirational language of democracy must prevail. And obviously, there will be answers for all of them in the majority, in the minority, and we might think differently. Different stakeholders might think differently, but that is what I think living in a democratic society is. I am quite worried about models of democracy, models of judicial adjudication, which purport to say, okay, this is what judges should do, and if they just follow these rules, we will be all okay. I don't think that's possible.
Great,
So we
thanks.
have only one more question to take.
Hi, is it me?
Yeah, sorry.
Hi, thank you. Yeah, thank you. Hi, everyone. I'm Vincent Joel. I'm visiting from NUS Faculty of Law until this summer, for those who don't know me. Thank you, Julen, for a wonderful, fascinating talk. Just a half-baked sort of initial reaction. I don't know if it's helpful, but some thoughts. What would happen to the dialogical model if you shift to state-to-state dispute settlement, right? So if you move in the international adjudicative context from or if you filter individual rights through the screen of the state, or I would argue the artificial screen of the state. I know that the European Court of Human Rights has state-to-state jurisdiction, but it's seldom used. So I have more in mind like the ICJ or courts of that nature. The ICJ, you know, doesn't have binding precedent, but believes in jurisprudence constante, as I'm sure you know, and is up until recently was very much all about self-citation, but that's sort of changing a little bit. In the Diallo compensation case, for instance, they started engaging with ECHR, Inter-American Court, Eritrea, Ethiopia Claims Commission. You see that to a lesser extent in the recent armed activities Congo-Uganda case, in a different but still relevant context in the jurisdictional immunity of the state, a case between Germany and Italy, same kind of thing. So my question is, what does that tell us when you shift from that sort of strictly individual adjudicative model to a more state-to-state basis? Does that tell us anything different? Are there other underlying sort of assumptions that might change the dynamic of the argument and that sort of thing? And just while I have the floor, very quickly to pick up, if you are going to pursue the state-to-state angle, to pick up on a previous point about the monological voice, obviously the ICJ also speaks as a collective, doesn't foreclose the possibility of individual opinions. I think the WTO has anonymous authorship as well of its reports and so on. So that's something also to consider, and to sort of tack on the point about reference. In Canadian constitutional law or elsewhere, you also have the advisory opinion mechanism at the ICJ, which I think would open up a world of possibilities in terms of the sort of dialogical implications. So just some initial reactions as food for thought, but thank you for a great presentation.
Thanks for the questions. They open up a new thing. I haven't really considered the ICJ. But my initial reaction might be then to say that I will have to think about it, and I will have to actually see how the practice is or is not open to the type of dialogical dimensions that I'm talking about before answering more specifically, because I think it changes from court to court, even though I do see certain phenomena, for instance, of judicial dialogue happening across the board in many jurisdictions. What I will then reply is that then we need to then see what are the jurisprudential implications of that model of borrowing, because it's not just simply to cite different courts around the world, but what it means then for the construction of the judicial voice. What does it mean then for the construction of the judicial authority? What does it mean then for how it is that the court understands themselves as interpreters? Or what does it mean for the rights which are being in question? So I think that thinking of FIT dialogically, what it does is makes it a bit more complex and more dense, but I also think it's more descriptively accurate. I don't like the word accurate, but more thick description. The WTO and the ICJ, so you're mentioning the question that Mary was raising about the voice. What I will say is that the voice is very, very important. So who is speaking, but also what it means that it speaks in the voice in which it does. And I think we can ask that of every text, of every proposition, of every sentence, like who writes as an analytical philosopher, right? You posit certain qualities whenever you speak in that language. And what I'm claiming perhaps normatively here is that we need to stop thinking of the monological voice as the voice that judges are supposed to be speaking, that there is value in opening up to more voices, to different ways of speaking. And this doesn't necessarily mean that judges will lose their authority. It will just simply transform the concept of authority under which we operate, which I define as relational. And I'm not sure whether I have another question, but we probably ran out of time.
Yeah, we have actually, and I think this is a nice way to end the session today. I just need to say that there is a note from Leora that probably it would be interesting to look into the practice of inter-American courses.
Yes.
Okay.
Yes.
Okay, so I wanted to thank all of you for coming to Faculty Colloquium Series today and on Zoom and also in person, and to thank Julen as well, and to invite you to come next week when we have a talk by our assistant professor, Robert Clifford. So thank you, Julen.
Thanks a lot.
Thank you all.
You're excellent.